that is State Bank of India. I belong to Andhra Pradesh. At present, I am in Hyderabad. And today's topic is on challenges in ineligibility of a successful resolution applicant under Section 29A of IBC Code. Everybody is aware of the 29A. But while selecting a good resolution applicant, lot of challenges are there. Number of resolution plans are submitted by the resolution applicants. And out of the particular resolution plans, we have to choose the best among the alternative. Here, the decision making is very, very important. Choosing the best for this evaluation matrix is there. But at the same time, the ineligibility criteria. So the ineligibility criteria is one of the important area, whether he is eligible or not. If at all I am selected a wrong candidate, then automatically the defunct or sick company, I am giving to another person who is not capable to handle that particular company. Thereby, the problems will persist. So that's why the ineligibility criteria is also defined by the IBC code under Section 29A. Today, I will give the in detail about how the 29A is evolved, the history, and all these things, judicial pronouncements, and all these things I will discuss in detail up to 5:30. And at about 4 o'clock, we will break for tea for 10 minutes. After that, we will continue for 5:30. History. So day one, the IBC code that is introduced in 2016. 29A is not there. Based on the experience, based on the bad practices that are happening while using this code, then they thought 29A is compulsory and inevitable. Prior to the introduction of the code, the BLRC, Bankruptcy Law Reforms Committee, submitted its report dated 2015, which laid down the shape of the code. Today also, whatever small gaps are there in the code, or whatever the small errors are there in the code, based on the recommendations of BLRC, the code is fine-tuned by the government. The BLRC report stated that a stereotype of rich promoters, defaulting entities, leading the idea of a default involving wrongdoing is a sign of a weak insolvency risk. If at all the same borrower who is defaulted, who is having the background is not up to the mark, if the same company is handed over to him, good results may not happen. The BLRC report stated that a stereotype of rich promoters of defaulting entities leading to idea that a default involves wrongdoing is a sign of a weak insolvency risk. As a result, the BLRC report emphasized on drawing a line between default due to wrongdoing or due to business failures. If at all business failures are there, definitely the government or the bankers or the financial institution, they will consider favorably. If a default is due to wrongdoings, the financial institutions may not consider that type of the accounts. And providing second chance, the honest debtors. So if at all he is doing the business in a better manner. But due to external environment, if the business failures are there, restructuring is one area that the financial institutions are handling. The second chance, definitely, because he knows the nuts and bolts of that particular company, the particular process, the creditors, the debtors, and how to minimize the cost, all these things, the promoter is the best person. In my opinion, that much skills may not have to the resolution profession or the wrong doers also. So that's why if genuine cases are there, definitely the company to be handed over to the same person, second chance is not a problem. But what is happening is the wrong people, they are second time also, they are going to handle the company, which is not correct. In line with these observations, when the code came into existence, no disqualification for the erstwhile promoters of the corporate return. At the time of implementation of the code, 29A is not there. No, there is no disqualification. Erstwhile promoters also can participate, they can participate to submit the resolution plan. But wrong things are happening. That is the experience. That's why BLRC, they have found this one and they have introduced, they have recommended the 29A. However, subsequently section 29 was introduced by way of ordinance. The objective to introduce the 29A is to provide a prohibition to certain persons for submitting the resolution plan who, on account of their antecedents, their background, whether he is a criminal or the defaulter or any disqualification as a director, so many lists is defined under section 29A, adversely impact the credibility of the process. If at all I am giving that defunct company or a problem company to a wrong person, then the same problem will persist and the economy will suffer a lot. So I have to hand over the company to the safest hands, not the others who are going to do the wrong things after take over the company. Section 29A, understanding the legal intent. What is the legal intent? What is the objective? As a evidence is the statement of objectives reasoning of the 2007 amendment, which has eventually replaced the ordinance, was to prohibit the person contributed to default of the corporate return or otherwise undesirable from misusing the provisions to regain the control of the corporate data at the expense of the creditor. The creditors, particularly the operational creditor or the financial creditor or the class of creditors, at the expense of the creditor, we should not sacrifice or we should not give that hand over the company to the others who are doing wrong things. If at all criminal is there or a disqualification is there, willful defaulter is there, his mindset is entirely different when compared to the honest the corporate debtor. Most of them are honest corporate debtors only. But to filter these people, the 29A was introduced. When the 2007 amendment was tabled before the parliament, much emphasis was laid down by the then finance minister. Without ineligibility of a 29A, the erstwhile promoters of CD would get an opportunity to get the same enterprises the back with a discount value. One side, he is defaulted. Second side, if at all the same person is allowed, he will acquire that particular company or purchase that particular company with a discount value. If the loan is 100 crores, again he will participate. He will purchase that particular company at 20 crores or 30 crores, where the huge haircut is also there, without discharging entirety of its obligation. Because once the default is there, and the same person, if at all I am giving that same company with a lower rate or a discount rate, it is not a justification. It is not a justification, not at the cost of the creditors. The amendment received presidential assent January 18, 2018, and a 2017 amendment also introduced the provisions of 35(1)(f), which is extended to the 29A liquidation proceedings as well. This is not only during the CIRP process to hand over the company to the particular the prospective resolution applicant, but also the disqualification is applicable in case of liquidation proceedings. People are ready to purchase the same assets, their earlier assets, with a lower discount at the cost of the creditors is not justifiable. So this amendment is also applicable, that is section 35, 1 subsection 1 clause F of the extended 29A liquidation proceedings as well. So the particularly IBC CIRP process part 1 and part 2, CIRP as well as liquidation. So this is applicable in case of the wrongdoers or wrong persons. They should not participated in the resolution plans, and they should not purchase the assets which are going to be auctioned by the liquidator. Why 29A is required? Some other people, particularly business concerns or the associations, they are objected. But BLRC, it is required. And some honest people, they are also suffered on account of 29A. So different people, different opinions are there on 29A. But which is the best one? That is as per the code, as per the regulation. Finally, in most of the cases, the adjudicating authority finalize. In some other cases, adjudicating authority, he has to take the call and he has finalized to hand over the company, sometimes to the existing promoters also. But decided cases are also there in this regard. Need for section 29A. Section 29 was introduced to curtail bar on the eligibility of the resolution applicant. It is a restrictive provision, specifically list down the persons who are not eligible to that, because some big list is also there. You have to filter the resolutions, applications submitted by the prospective resolution applicants. Section 29A is entirety, not only the restrictions of the promoter, but also people related or connected parties with the promoter. It is not only the person who is going to submit the resolution plan, but also the connected persons or related party also we have to verify. So this process is a big process, challenging process. Lot of data is also required. Background verification is required and homework is also required. Finally, you have to make a conclusion that he is the right person. He is a fit person to take over that company. Then only the company will survive. Once the company is survived, then economic loss will not happen. Opinion of experts. Some experts or financial creditors' opinion is also there about the 29A. What is their opinion? Nevertheless, 29A is excessively enlarged the scope of disqualification. Everybody has its own opinion. But experts and financial creators, their opinion is excessively enlarge the scope of disqualification to the extent of drastically reducing the prospective resolution. If at all the number of people are more, definitely competitive spirit is there. Finalization of the resolution plan, they due to that, what is the tender system? In the tender system, we will always H1, highest one. And to get the highest one, if a limited number of people are there, the competitive spirit or the price of that particular company will reduce. So here, the financial creator or experts, their thinking is like this, and excessively enlarging the scope of disclosure, the extent drastically reducing the prospective resolution. The number definitely will reduce. If at all, that's why earlier the subprime lending crisis is there in the USA. Most of the banks, they're always thinking about a prime lend, prime borrowers. And some experts, they told, why you are more concentrating on prime borrowers, why not subprime borrowers? And whoever is defaulted with a credit card or other banks, they drag and give the loans. Then everybody has seen the picture of the subprime lending crisis. And most of the US banks are suffered on account of subprime lending. Here also, okay, some financial creditor or experts, they are thinking that no, the prospective resolution applicants will reduce. Correct, no doubt at all. Once I have filtered the ineligibility people, definitely the number will reduce. But that is also good. In future, he has to handle the company with more careful, and the problem of the earlier promoters, the same problem will not arise. Labeled generalized criteria for a disqualification, wherein does not differentiate between a genuine applicant and with the one with the antecedents. But the 29A is a defined a disqualification, particularly who is a genuine. That also, if they defined, then it is gives us some comfort level to the COC or the resolution professional to identify the best resolution applicant. They list out the disqualification, but a genuine applicant's antecedents, if at all you verify and the clean slate is there, definitely you take it that people, definitely some good results will happen. But some adjudicating authority views are also there. Some NCLT or NCLTs, their views are also 29A. Similar views are expressed by the NCLT in the matter of RBL Bank Limited versus MBL Infrastructure Limited, wherein it was expressed that it cannot be intention of the legislature, but disqualify the promoters as a class, but rather exclude those class of persons who may affect the credibility. This is not a disqualification, but those persons who may have affect the credibility of the resolution process given their backgrounds. So they interpret it in a different manner, particularly in RBL Bank versus MBL Infrastructure Limited. However, the NCLT Mumbai bench also in the matter of a Wing Associate Private Limited gave ruling completely disregarded the wordings of the Section 29A by allowing the resolution plan offered by the applicant who is related to the directors, which is completely against the 29A. The company Wings, which has applied to Section 10 of the IBC, triggering CARP process against itself in the August 2000. So different people, different opinions are there. But finally, which is the best one? It is a very definite. That's why it is a biggest, the challenging one to the various people, whether you call it as a financial creditor or the adjudicating authority or etc. associations of industry leaders, etc. It appeared that at that time that the Bank of Baroda is a sole financial creditor. And the Wing associate reached a one-time settlement with Mahendra Wing for the settlement of outstanding. So that is also correct. Only one sole financial creditor. That too, one-time settlement, the same borrower, if at all that is handed over, or a related party of the borrower, if at all it is handed over, then he will manage the company effectively and efficiently. Before offering the one-time settlement, why he is defaulted? What could be the reasons for that? And if at all its genuine reasons are there, take for example, pandemic COVID pandemic COVID 2019. Number of MSME units are struggling a lot on account of the shutdown or lockdown, and the liquidity problem is also there. For those companies, definitely, if at all bankers are filed, that is not correct. Why? Because even government of India also, they have come into rescue and sanctioned emergency line of credit to them. So here, completely not ruled out the genuine borrowers. We have to give some opportunity second time to the genuine borrowers. It appeared that the time of at the time that the Bank of Baroda, a sole financial creditor, and Wing Associated reached a one-time settlement with Mr. Mahendra Wing for the settlement of the outstanding. That is also correct. That is also correct. One-time settlement. They offered the haircut is very less, and anyhow the same borrower will continue. Same borrower with with more cautious approach, he will try to run the company in a better fashion. That is also very, very important. To comply the provisions of IBC, Mahendra Wing offered resolution plan, which is approved by the Bank of Baroda, which was later submitted. The following expression of interest floated. Only 1 minute, sir. Only 1 minute, sir. Sorry for the interruption, sir. To complete the provision, Mahendra Wing offered the resolution plan, which was approved by the Bank of Baroda, which was later submitted. The following expression of interest floated in April 2000 after the IBC amendment 2018 ordinance was also passed. Sorry, it is a balanced approach. And some adjudicating authority, they are taking their own decision based on the facts of the case. And case by case, in some cases, it is deferred. Now coming to the next point, opinion. Some of the people opinion is need to encourage restructuring rather than liquidation. Some of the financial creditors, they are telling, or some borrowers, they are telling that restructuring is better than the liquidation. The Insolvency and Bankruptcy Board particularly amended the IBC, IBBA Regulation 2016 and the Liquidation Regulation 2016 states. Under the amendment introduced the liquidation process, ineligible persons are now barred from being part of compromise or arrangement at the stage of liquidation. Earlier it is there. Particularly the compromise under section 230 of the Companies Act. The compromise and arrangement. So during liquidation process, no question of compromise or arrangement. So under the amendment introduced, the liquidation process regulation, ineligible persons are now barred from being part of the compromise or arrangement at the stage of liquidation. And further, The secured creditor also choose to sell the secured assets independently, also cannot sell them the same person who is ineligible under IBC. So sometimes, if at all buyers are not there, bidders are not there, first notice, second notice, third, in the meantime, the asset value will be decreased on account of rusting, on account of non-usage, on account of a time lapse, and the time value of the money will also decrease. So here, some people they are thinking in a different manner. That is also correct. 29A is also correct. Whatever BLRC findings, that is also correct. And here, in my opinion, balanced approach is very much required. This has been introduced specifically overrule the decisions passed by some NCLTs, whereby held no bar operated on the sale of secured assets to the ex-promoters of the corporate debtor if such sale is carried out by a secured creditor under Section 52 of the IBC. That's right. Section 52, what it says? Section 52 of the IBC outlines the rights of the secured creditors during liquidation proceedings. Rights of the secured creditors. It allows them either relinquish their security of interest to the liquidation of asset or realize the security interest by enforcing their rights as per the applicable law. Ultimately, recovering their dues from the proceeds of the sale. Here, relinquishment. If at all secured creditor, I don't want to sell, you sell, and whatever the sale, the sale purchase value is there, the sale value is there, you place a credit to the loan account like that. So here, Section 52 of the IBC outlines the rights of the secured creditors and allow them either relinquish their security interest to the liquidation estate or realize their security interest by enforcing their rights as applicable law. Ultimately, recovering their dues from the proceeds of the sale. The opinion of the corporate debtors. The opinion of corporate debtors, what is their opinion, or particularly with regard to 20. Since many believe that genuine promoters will become ineligible and there will be no competition between the acquirers and bidders and promoters, and due to which creditors will not receive adequate consideration. The corporate debtors version is also correct. Once the number of people are reduced and the promoters are not participated in the bidding process, that is a submission of a resolution plans. Once the promoters are there, they know what is the value of the company. Because so many years, they know the nuts and bolts of the particular company. And what is the worth of the particular plant and machinery? What is the worth of the building? What is how to get the things, particularly how to get the production with the least cost, and who are the buyers, who are the sellers, all these things he knows. He is the best person. And the bidders, due to which the creditors are not receive adequate consideration. Once if the promoters are not there, the bidding amount will reduce. Once it is reduced, some creditors will get the amount, most of the creditors will not get the amount, or the hair cut will also be there. So the opinion of the corporate debtors are also good, correct, to some extent. Opinions of the manufacturing associations. Some manufacturing associations, their quick disposal of assets taken possession by the banks due to borrower default is crucial. Today, even under Surface Act 2002, banks are giving a notice under Section 31(2) or 32(4) like that. And they are taking into possession of the assets. One example I am quoting recently, one of the corporate debtor, the bank has taken the possession of the factory. And the last 2 years, the bank is unable to sell the factory. Thereby, the complete rusting of that particular plant and machinery, and the building is also dilapidated condition. Today, if at all you show to the prospective buyers, most of them are reluctant to do that one. So here, quick disposal is one of the important area. Otherwise, over a period of time, the treasury value becomes zero also. And the quick disposal of the asset taken possession by the banks due to the borrower default is crucial. Delaying the sale can decrease the value of the asset, making it harder for the bank to recover the outstanding dues. If at all I have taken the 29A, the number of buyers will reduce. And I am restricting the existing, the corporate data. Thereby, the problems are there in a recovery to the financial institution or to satisfy all the creditors in the particular system. Opinions of the manufacturing association. If at all you are not taken our plans in the CIRP process and barred, we are they not they eligible to participate. Then what is the problem to the bankers? What is the problem to the financial creditors? And they express their opinion of the manufacturing association. Particularly the business concerns opinion or manufacturing association's opinion. After moratorium period starts, RP take the charge of the data company with the sole objective of protecting the assets and fundamental operations. It is on the paper. How many people are protecting the assets? If the assets are properly insured or not, and whether the assets are secured by the security guards or not. And some of the assets over a period of time, if at all proper maintenance are not there, then automatically the value will be depreciated. And it is a one-man show. So the resolution profession also only one-man show. And runs the affairs of the country. He is called as a CEO of the company, of the data company. The amendment is filling the gaps in the insolvency law also. The opinions of the manufacturing association. Here is why swift disposal is important. They are telling, if at all you are restricted 29A, quick disposal is not possible. But if at all the existing corporate data is also participated, quick disposal is possible. Their opinion is like that. Their contention is first asset depreciation. Normal depreciation is there. Due to non-utilizing of the asset, further depreciation will happen. If at all there is no maintenance, there is no lubrication of the plant and machinery, definitely the plant and machinery value will be depreciated. And the technology obsolescence rate is also one of the important area. Once I have sold that particular plant and machinery, after 2 years, this is an old version. Today, the latest technology is there. This machinery is not at all useful. Then it will become zero. Their opinion is like that. The manufacturing association. If at all that is also, they are also participated in the resolution plans, this problem will not arise. That is their opinion. Assets, especially subject to wear and tear or the market fluctuations, can depreciate the value over time. The longer the financial creditor holds on asset, the greater risk of the value decreasing. Value decreasing not only on account of depreciation. Once the inflation rate is there, definitely today 100 rupees is not equivalent to tomorrow 100 rupees or after 1 year 100 rupees. That is on account of inflation rate also. That's why the time value is one of the important in the preamble of the IBC code. Storage maintenance. Today, I have given one big company and some assets, whether all assets are properly protected or not. Is it possible for the resolution professional to look after? If at all erstwhile management is there, they know each and every item. They know how to protect it. Storage and maintenance cost. And storage and maintenance assets, especially real estate or equipment, can incur significant cost. These costs can erode the bank's potential profit from the sale. That is the manufacturing association version. Next, market volatility. So, market conditions change quickly, and a delay sales could mean lower price if the market shifts negatively. That problem is also there. So that's why quick disposal is very, very important. If at all the basket of the prospective resolution is widened, definitely this type of problems will not arise and increase the deterioration. If an asset is not properly maintained, while in the bank's position, it could be deteriorated further, reducing its marketability and value. As I told earlier, technology obsolescence rate is more. Today, plant and measure after 6 months, the modern updated version, technology, latest development, it reduces the cost of production. All these things are there. If at all I have not used that particular plant and machinery, definitely not only the basic depreciation percentage, but on account of non-usage, the depreciation percentage may be double or triple like that. That's why the manufacturing associations, they told, don't restrict, don't they please allow the corporate debtor also in the participating the resolution plans. Efficient recovery. Quick disposal of the bank recovery is due faster and reduce the burden of the non-performing asset. If at all you are seeing this is all our manufacturing association from time to time they are also commenting. That's why 29A they are thinking, they are also ventilating their views to the ministry also. Why can't you allow the earlier promoters? Okay, if at all you are always thinking about the discount or other things, COC is there. They will look after that. If at all we are offering a higher discount, they may not allow our proposal. Who is the H1, the highest one? Definitely they will allow. And the evaluation matrix and all these things are there. That is their version. Efficient recovery, quick disposal allows the bank to recover its dues faster and reduce the burden of the non-performing on its balance sheet also. Not only that one, business concerns expectations. What is their expectation? Weighing the uproar of the created by the ordinance, the government is considered revisiting the blanket restriction provided under the ordinance and is expected to announce a certain relaxation to the tough eligibility requirement for the bidders, that is a resolution provision. Because the industrial associations are also not in favor of that particular restrictions, they are also presenting their case to the appropriate authorities from time to time through the merchant chambers or industrial associations, etc., etc. And it clarified that the position of the promoters and management of the corporate process of insolvency liquidation. It removes the contradiction between the IBC and other acts. Some difference is also there about this 29 when compared to IBC vis-a-vis other acts also. And particularly surface and recovery, asset recovery. The Surface Act provides a legal framework for the banks to the position of the secured and enforce security interest without court intervention. Everybody knows about this one, that Surface Act 2002. This allows banks to streamline the asset recovery process and prevent further erosion of the asset value. In essence, quick disposal of the banks minimize the losses and recover their dues efficiently while contributing the stability of the financial system. So this is the opinions, various opinions of the manufacturing association across the country. Now coming to 29A in detail. Everybody knows about the Bhushan Power Steel Limited. The resolution professional not verified the properly the prospective resolution applicants. That is one point in this particular Bhushan Steel's recent verdict of the Supreme Court of India. So, non-compliance of 29A, that is one item in that particular verdict, Bhushan Power and Steel Limited. The court noted RP has not submitted mandatory compliance certificate. Today, most of the RPs, they are giving Form 15H and they are putting their efforts. But in a big country like India, to get the information about the particular person, very, very difficult. So technology is there. With the help of technology, to some extent, it is possible, but to a large extent, it is not possible. So with their whatever the antenna is there, particularly the resolution applicant antenna, they are verifying, and finally, sometimes it is impossible also. And they are as per the regulation, they have to give the certificate that I have verified thoroughly. He is a correct person. He is not no disqualification like that. Verifying JSWC ineligibility under Section 29A of the IBC. Here, verifying means certificate in is not produced in this particular case. He may be verified, but once he verified, certificate is to be attached. Once a certificate is not there, the adjudicating authority has to raise that point that was slipped. Once the adjudicating authority had it been happened earlier, then this point is not arised in the recent Supreme Court verdict. So Form H compliance report is also one of the regulation. Court emphasizes that the eligibility of the resolution applicant goes to the root of the matter. And the failure of to properly verify and certify the affidavit raised serious doubts about the JSW's eligibility. So once the certificate is not attached, different people, they will think in a different manner. Their opinions may be different. But here, the certificate to be, the affidavit is to be given by that particular resolution applicant. That is missing in this particular process. So once it is not there, normally the adjudicating authority or Honorable Supreme Court of India authority also, they will pinpoint why you have not submitted, why you have not verified. Once you have verified, what is the problem in submitting the Form H? And some doubts, they will definitely, as a human being, if at all that is not there, doubts definitely it will arise. And failure to properly verify and certify the affidavit raised serious doubts on the JSW's eligibility. But it is notable that while non-compliance of the procedure for certification eligibility was held to be a significant lapse, that is 100% lapse, on the part of the RP, 100%, but there were no findings of JSW's eligibility. That is luckily, in that particular case, no ineligibility criteria of JSW is not there. Okay, that is the lapse on the part of the significant lapse on the part of the resolution professional, but there was no findings of JSW. Ineligibility is also, that is not there, luckily. Now, verification of a prospective resolution applicant under Section 20. So talking about the verification is a very, very important area. And once during that verification process, the ineligibility applications are to be removed. Only eligibility, we have to prepare the evaluation matrix. The two model evaluation matrix that are defined by the IBBA. So today, the verification process is a very, very, very difficult and challenging one. So many areas are there. Some of the areas I will discuss in detail. To verify the prospective resolution applicant under section 29A of the IBC 2016, the resolution professional must conduct a due diligence. Sky is the limit here. So, in a big country, people are moving from one place to another. People are starting the different companies. One company closed, new company they established, and with a different management. And some of the banks, even though CIBIL and other things are there, some of them are reflecting in the CIBIL reports, and some of them are not reflecting. And all these things, the gaps are there, including the verifying application eligibility against the various disqualification outlined in the section. If you go through the section 29 details also, I will go through, I will discuss about that one also. But here, the disqualification verification is a biggest challenge for the resolution. Today, so many firms, we will verify, this is the cost, that is the cost. Even in India, Dun & Bradstreet is also there. They are having large data about all corporates across the globe. And even small firms, they are telling, I will verify means they don't have that much infrastructure like servers, etc., etc. And if they are telling like that, what is the authenticity of the accuracy of that particular report? Daily, if at all we are in this field, daily we are receiving some emails from some firms. You need not worry about that one. We will verify like that. So how they will verify and what is the authenticity? All these things is the biggest problem. Thorough due diligence is a it is a Herculean task also. This involves scrutinizing the applicant's background, his financial standing, and the potential conflict of interest, acting jointly or consult with others, or in relation to the corporate data. So it is not only one individual's report, and his financial standing is required, and a potential conflict of interest is also there, acting jointly or consult with others, or in relation to the corporate. All these things are to be verified. To verify the prospective resolution applicant under section 29A of the IBC, the resolution needs to assess applicant eligibility based on various factors, including financial status, criminal record. The criminal record, some places it is centralized, some places it is decentralized. How to get that whether he is they involved in any criminal activities or not? Past involvement of the corporate data. Even though the MCA 21, the website is there, and earlier data is also not sometimes it is very difficult to get the data, past data. So here also, because the stripping of the data is also there, and sometimes it is possible, sometimes it may not be possible to get the old data about the credentials of that antecedents of that particular director or the borrower, etc. The verification process involves checking the ineligibility criteria, such as being a willful default, having an account of non-performing asset, or being convinced by certain offenses. So non-performing assets. So today, well, 1 year back, I have seen one Reserve Bank of India circular. One borrower with one property availed with 27 banks with the same property. He has taken a duplicate from the sub-registrar office and he used the duplicates and availed loans with 27 banks. So that is the Reserve Bank of India circular. So even banks' centralized system is also not there. Okay, today SARSA is there under Surface Act 2000. Whenever the banks are giving loans, they will enter into that particular SARSA, and it is a centralized database of loans that are provided by the banks to various individuals or business entities like that. What about the old data? Okay, whatever the current the borrowers are there, it is very easy to enter. What about the old data? This verification was checking of ineligibility criteria such as belong willful defaulters. But a willful defaulter, again, we have to go through the Reserve Bank of India circular. Willful defaulter means they have given some the conditions. All conditions are to be satisfied. Then only we have to declare the willful defaulter. And having an account with a non-performing asset or being convicted by certain offenses. All these things have to be verified. One, few verification methods are there. After that, I will discuss what are the section 29 as defined under the Act. That also we will discuss. What are the various methods at present? Checking willful defaulters. RBI can really list on willful defaulters published by the Reserve Bank of India and individual banks. Today, even banks also, some of the banks, on paper, the RBI published the willful defaulters, where it is available, how to extract, how to verify, how many fields are there, and what is the search command. All are question marks. Even auditors also, particularly due diligence certificate, that is to be given by the auditors wherever consortium finance is there. In that proposal also, whether he is a willful defaulter RBI or not. Some of the operating staff, they are unable to get the data and where it is available. But I have seen that the data and updated the 2 years back or so. But where to get? If at all it is available, if IBBI is provided that link to that particular all RPs, then it is very easy for the RBI to verify the data. Even they don't mind to pay the amount to extract that data like CIBIL data. And the website of the Credit Information Bureau can also be used to identify willful defaulters. Today, CIBIL data. CRIF high marks is there. The nearly 4 companies are identified by the Reserve Bank. Some of the borrowers, it is showing in one CIBIL report, it is not showing in other CIBIL reports, other credit information reports. If that is the case, how to verify? Suppose CRIF high mark is there and TransUnion 2 companies are there. If one borrower, last week only I have seen, one borrower, he is the CRIF high market is showing as a default, but whereas in TransUnion it is not showing. So that's why the Reserve Bank recently given real-time basis, the credit info, the credit information, the CRISIL or CRIF, they have to update their records on real-time basis. If real time is there, the bank servers are to be directly linked to that particular companies. And if at all that data is accurate and PERFCA, then IBB has to provide that information to the RPs. Then only the accurate 29A accuracy will increase. Otherwise, because of whatever the efforts are there, they are putting that efforts and at last they are giving affidavit. If something was happened, then automatically the IPS will be blamed by the disciplinary committee of the IBBA. The checking of willful defaulters, analyzing financial statement. The RP should they examine the financial statement, including the audit statement for the past 3 years. This helps applicants of financial stability, ability to fund the resolution plan. So whether he is capable or not. Suppose the sales are increasing trend year on year basis, profit is increasing trend. So to some extent, we will believe that the existing company is in good condition. If at all tangible net worth is decreased, or the current ratio is in bad, or debt equity ratio is in bad, how we will presume that he is a good person or a credit worthy person to take over the new company, the corporate data company? Then all are a challenging one. Verifying KYC, address proof. The RP must verify the applicants know your customer document and address proof. Whatever the DIN is there, whatever the Aadhaar is there, whatever the PAN card is there, all are address proof. Today, shell companies are also increasing. Shell companies are also increasing. That is 3 to 4 years back. I have visited. I have my bank, that is State Bank of India, given 5 accounts to me. 5 accounts. The 5 accounts, Mr. Prasad, you please verify whether normally the bankers they will verify the loans accounts only, not the deposit accounts, particularly current accounts. If at all company is going to open an account, we will ask the memorandum of association, articles of association, or certificate of commencement of business, or certificate of incorporation, or board's resolution. All these things we will take and we will open the account. We don't want to visit to the depositors or company's premises, and thereby I visited that 5 company, the 5 company address that is provided in the KYC document, and the 4 companies are good. 5th company, it is located in one apartment. In that apartment, 2-bedroom portion they have taken outside with a gold color. So and so private limited company is there. Then I asked the particular security guard when they will open this company. No, sir. Every 2 months they will come and they will chit chat and they will go. But if you see in the company's account, crores of rupees turnover is there. But no production department. They are not doing any type of a business. So that's why the Minister of Corporate Affairs, they wrote a letter to the Reserve Bank of India. Number of shell companies. So that's why recently that Reserve Bank of India, that is 2 years back, they have given revised guidelines for the bankers while opening the current accounts also. This confirms the application identity and a location. Checking the ineligibility under Section 29A. RBI needs to determine the applicant ineligible under any of the clauses. So many clauses are there. I will discuss about all these clauses. Such being undischarged insolvent, having conviction of the specific offense, or being a disqualified director under Companies Act. All these things are to be verified. So here it is a difficult task. Once it is completed, you have to give the affidavit. If at all any dilution takes place, then tomorrow the NCLT or any adjudicating authority, they may raise this gaps. Investigating a related party. It is very, very difficult. Whether he is a relative or it is very difficult to establish whether he is a related party or not. Even company secretaries of India also, related party is a big subject. Or we should investigate whether the applicant is a related party of the corporate data or acting in concert with such party. Or this includes checking of the relationship with the promoters or managers or controllers of the corporators. This is also a big task, whether he is related or not. How to establish and checking the guarantees and enforcement. Today, if at all I have taken loan, it will be reflected in CIBIL. If at all I have given a guarantee to the other person, in some cases it is not reflected in my CIBIL report also. But the commercial CIBIL, the company's CIBIL guarantees are also reflected now, not earlier, not earlier. The RP must verify the applicant person acting as a consent with them has provided guarantee to the creditor in respect of the corporator. If a guarantee has been invoked, remains unpaid, it may be the disqualifier of the applicant. So that's why the guarantees are also to be verified, if at all he is a guarantor or not. Today, particularly the personal guarantor to corporate debtor, is difficult for the resolution profession to identify the assets under his name. It is a difficult task. If at all you ask that guarantor, no, sir, now my age is 70, the crossed, I don't have any asset, all are distributed, and now I am taking food in my son's house or daughter's house like that. Today, number of cases are filed with NCLT under the personal guarantor to corporate debtor who are the erstwhile directors of the companies. But to get the repayment plan from them is very, very, very difficult. So checking of the guarantee or enforcement is also one of the area. Seeking affidavits. Okay, last resort. To safeguard our skin, we are taking affidavits also. The RP can acquire the applicant to submit affidavit stating their eligibility under Section 29. So to protect themselves against the disciplinary action that is to be taken by the IBBA, if at all any gaps are there or slight mistakes are there. This allows the applicant to declare compliance with the ineligibility criteria. The RPs are putting their efforts, lot of efforts, and finally they are taking this affidavit from that particular the resolution applicant also. Reviewing the corporate records. RP should review the corporate records of the applicant to ensure they are not barred from acting resolution applicant. And this includes checking of the relevant orders or decisions by the NCLT, etc. How many servers? Any single server is there. If all the information is available, then whatever the data is required, we will input the data and get the output. But different servers, different organizations, and the 29A is a big list. It is a very, 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 very challenging one. Key considerations. The RP role is to ensure the resolution plan is compliant with the 29A and the resolution applicant is eligible. You have to confirm. You have to give the affidavit also by the RP after thorough verification. This is pointed out by the Honorable Supreme Court of India in Bush and Stills also. The Committee of Creditors also play a role in assessing the resolution applicant eligibility. The Committee of Creditors bankers, they are not fully involved in this area. Whatever the proofs that are provided by the RP or whatever the information he is provided, they will take a call in the meeting and they don't involve in the completely the process. That is a decision making authority. They are not operating areas, particularly the in-depth investigation about the prospective resolution application verification, they don't involve. The involvement is completely bank on, depending on the RP's efforts only. The NCLT has the power to approve or reject the resolution plan based on its compliance with the section 29. Whatever the RP is submitting, after thorough verification, whatever the efforts are there, he will made and finally the affidavit from the prospective resolution plan applicant, he will submit the affidavit, all these things or civil report or whatever the available information is there, he will collect and finally he will tell, I also verified like that. But it is not foolproof. It is not a foolproof. But for this also, some supporting systems are also required. That is to be provided by either information utility. Because now the digitalization of bank advances are happening through the information utility. And to some extent, that information is also available for the RPs to determine whether they have taken avail loan, any loan or any non-performing asset along with the bank's reports, etc., etc. Now, coming to the judicial pronouncements. The judicial pronouncements. What are the judicial pronouncement with regard to the 29A? So I will discuss about some judicial pronouncements with regard to 29A. What are the 29A? SRI, multiple asset investment trust versus IDBA bank and others. Section 29A of the code refers an undischarged insolvent is applicable to individuals and partnership firms. Section 29AC would not be applicable to the resolution applicant who acquired CD pursuant to the prior resolution plan approved under the code. Prior or the resolution applicant who acquired the CD pursuant to the prior resolution plan approved by them. So this is a SRI, the multiple asset investment trust versus IDBA. And SBI Global Factors Limited, Sana Synthetics Private Limited. The defaulters are disqualified under 29A should not get any benefit under the code. Correct? This is a clear message conveyed through section 29. Okay. A defaulter must not be benefited by entering into those very assets through side doors or otherwise not permitted to enter front doors. That is a submission of resolution plan. Because the ineligible candidates, they will try various ways and means. Either side doors or front doors is not possible, though they will choose the side doors. But being a resolution applicant, we should be cautious. Otherwise, it is a very, 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 very difficult for us. Oslo Mittal India Private Limited, Satish Kumar Gupta and others. In this case, 29A de facto opposed the de jure the position persons mentioned therein. This is a typical to see through provision that one can see who actually in control, whether jointly or consent. The purpose full of the contextual interpretation of a section 29 imperative to cut corporate will. What is meant by corporate will? Find out the real individual's entity acting jointly or consent with the submission of the resolution plan. Now, what is meant by corporate will? The corporate will is a legal principle that shields the shareholders and officers of the company from personal liability of the company debts and obligations. They are under the shield of the corporate will. So the corporate will is a legal principle that shields the shareholders or officers of a company from personal liability of the company's debts or obligations. So whatever the losses and whatever the happen in the company, they are not responsible from their assets. It is essentially treats that the company is a separate legal entity from its owners. That is called corporate will. This means a company faces lawsuits or financial difficulties. Its owners are generally not personally liable from the company's obligation beyond the value of their shares. But some of the people, they want to save whatever the wrongdoings are there. They want to use the corporate will. That is, we have to verify that one. So they want to escape under the shield of the corporate will. So we have to verify that one. We have to thoroughly verify that one. Take for example, LLP is there, limited liability partnership. In the limited liability partnership, the liability of the particular shareholder is up to the share value. If at all they are doing wrong things or fraudulent, their liability is unlimited, not a limited liability. So some of the people, they are escaping due to this corporate will. So we have to verify thoroughly in this regard also. Sandeep Kumar Bajaj and another versus State Bank of India. Section 29A or Section 31 would not provide shield against the Section 14.3, the 14 subsection 3 clause B of the code, and the corporate debtor and promoter would not come under the immunity of the blanket of Section 14 as the same contrary to the governing of the CIRP and RBI guidelines. Now, what is meant by Section 14 subsection 3 clause B? So, what is that one? Section 14 subsection 3 clause B of the IBC provides exception to the general moratorium declared under Section 14 subsection 1 regarding against the sureties and guarantees. This means the legal action can still proceed against the guarantors, sureties, even during a moratorium period also. Some of the people, they want to escape from this one. And no, as a moratorium does not shield the corporate debtor from the liabilities under the guarantee contract. So some of the guarantors, they want to escape because the company is under moratorium, the corporate debtor is under moratorium. So they are thinking that this is applicable for them. No. So this means the legal actions can still proceed against the guarantors or the sureties even during the moratorium period, as a moratorium does not shield the corporate debtor from the liabilities under the guarantee contract. State Bank of India, Anuj Bajpai. In this case, the NCLT held that if it comes to the notice of the liquidator that a secured creditor intend to sell the assets of the person who is ineligible in terms of Section 29A, it is always open to reject the application. Under Section 52, subsection 1, clause B, read with Section 52, subsection 2 and 3 of the code. So, if at all the financial creditor not relinquished the asset and he want to sell the asset, then they have to follow the 29. If at all it is known to that particular adjudicating authority, we will give the orders in this regard also. The certificate issued by the Minister for MSME raise no objection to the fact of the corporate data is an MSME. That's why this exemption is there, particularly to promote the MSMEs who are struggling a lot in the economy. Because we know, everybody knows about farmers born with debt, lives in debt, dies with debt. In the similar manner, in the corporate world also, MSC is a small corporate. But these people are also struggling a lot because on account of size, because they are unable to compete with the big firms, because large scale economies problem is also there. So all these things are to be taken into consideration, and they are giving bread and butter to the economy by way of forex reserves, by way of GST contribution, by way of employment opportunities, by reducing the regional imbalances. All these things they are providing. That's why the government of India thought that the MSME should be exempted. They are also eligible to participate under in the resolution applicants, and this disqualification of 29A is not applicable to the MSME sector in the economy. P. John versus St. John's Freight Systems Limited. The promoters or employees of the cooperative without knowledge of RP had secured the registration certificate of MSME Act to overcome the bar of that particular 29A of the code and submitted their resolution plan. The same is not approved by the Committee of Creditors. Although no other resolution plan is submitted under this, the adjudicating authority ordered the liquidation of the corporate debtor. Does not have any legal flaw. So here, particularly, there is no other resolution plans, but only one resolution plan. But in this case, the adjudicating authority judgment is a different one. Even though it is an MSME, their staff members, they Udyam portal, they went and they registered and they submitted their resolution plan, and adjudicating authority not accepted, and the order of liquidation for the CD. So sometimes this type of judgments, once there is no resolution applicants, and if at all the liquidation is there, they will sell pieces, plant and machinery, land and buildings, like that. One by one, they will sell. After that, the company will die. And once it is a going concern, it is not possible in most of the cases in liquidation process. Even CIRP also, we are talking about going concern. How many companies are running well on account of the CIRP process? And even liquidation also, we are talking about a going concern. The total company as a whole, we have to sell. And going concern means whatever the plant machinery and all should be in running condition. Then only the value, the particular value of the property will increase, and it can satisfy to a large extent to all the creditors of the company, whether it will be the financial creditor or the operational creditor. Arun Kumar Jagat Tramaka versus Jindal Steel Power Limited. Upholding constitutional validity of the regulation 2B of the liquidation process regulation, the Supreme Court provision of 29A and section 35, subsection 1F of the code must also attach to the scheme of compromise or arrangement under 230 of the Companies Act 2013, where the company is undergoing liquidation under the code. So here, the 29A, they are applying to the compromise and arrangement under section 230 of the Companies Act. I will discuss about the 230 of the Companies Act. Even in the absence of the said regulation, the person ineligible under section 29A, read with 35 subsection 1 of clause F, is not permitted to propose the scheme for revival of the company undergoing liquidation under the code. What is meant by the compromise and arrangement? In this particular company, undergoing liquidation pursuant to the provisions of the chapter 3 of the code of the liquidation process, it would lead to manifest absurdity. Very persons are ineligible submitting the resolution plan, participating in the sale of assets of the company in liquidation, or participating in the sale of the corporate data as a going, and some permitted to propose a scheme. The same rationale permits the resolution process under chapter 2 by virtue of 29. And the expression, particularly in case of Telangana State Trade Promotion versus AP Gems and Jewelry Park Private Limited, expression of control. Here, the expression of control means positive control, that is a mere power to block a special resolution of the company, cannot amount to control. In reality, the word control compared to the term management means a de facto control, actual management decision that may be or taken, reality taken. So here, the various judgments that are pronounced by the judiciary authorities are in a different angle. They are giving, particularly in Digambar, Anandarao Pingal and Shrikant Mandal Jawar, erstwhile RP of so-and-so builders. After CIRP initiated, farmer promoter and director cannot suppress the IRP or RP and apply for MSME certificate tied over the ineligibility of the section 29 after the code. After CIRP initiated, farmer promoter or director cannot suppress from the IRP or apply the MSME tied over the ineligibility of the this one. So whatever the certificate is there, MSME, with the consent of the particular RP, and if that is submitted, then it is a valid. Otherwise, it is not valid in most of the judicial pronouncement. This is mentioned. And the Swiss ribbon constitutional validity of 29 was upheld in the Swiss ribbon and the Union of India. And Servana Global Holdings and Buffana Pharmaceutical Limited. The intention of the legislator promotes MSME should be encouraged to bear back the amount of satisfaction COC to regain the control of the CD and filing of the resolution, which is viable, feasible, fulfills the other criteria laid down by the IBP. So particularly the purpose is also the good purpose, because to protect the MSMEs for this CIRP, this is a good purpose. Actually, the two benefits that are extended by the government of India, particularly for CIRP, one is under IBC, one is the MSMEs can also participate in the filing of the resolution plans. The second one is the pay-back insolvency. That is required in Indian conditions also. That's why most of the judiciary authorities, adjudicating authorities, they are giving some positive opinion. They are having the positive opinion about the MSME segment, And this is displayed in their the judgments also. Jindal Power, Steel Power, and Arun Kumar Jagata and the promoter is, if eligible under 29A, cannot make an application for compromise and arrangement for taking back the immovable and movable properties auctionable claim. So once he is eligible and they are not eligible under he is ineligible under section 29, and he cannot make an application for a compromise and arrangement. What is a compromise and arrangement? That also I will discuss later on. Now, we are talking about 29A, 29A, 29. What is a 29A as defined in the code? What are the various parameters and what are the areas to be verified by the resolution professional to take a call or to take to evaluate whether he is a correct person or not, whether he is disqualified or qualified. That is very important. For that, the detailed explanation of 29A we will discuss after the tea break. Next, we will take a tea break for 10 minutes. After that, we will meet and we will discuss about the 29A in detailed manner. Is it okay, sir?
Okay, sir.
Okay, sir. Now we will discuss about the detailed explanation of what are the various subsections are there in 29A. Today, the most litigation initiated under IBC relates to Section 29A. This section provides extensive disqualification criteria for the resolution applicants, enlisting who shall not be eligible to submit the resolution plan. The resolution plan is to serve the benefit not only to the creditors but also stressed corporate debtors. Both are be benefited because once the prospective resolution applicant is a good man, competent man, and businessman, definitely all the stakeholders will be benefited, particularly the financial creditor, the first person, because under the waterfall mechanism, after the CARP cost, the secured creditors, definitely they will be the beneficiaries and they are in the first in the queue after CARP cost. And not only the creditors, but also the stressed corporate debtors. So once I have chosen the best resolution applicant, definitely in the waterfall mechanism, the last person is the equity shareholder. Definitely he will also be benefited. And if at all he runs the company in an efficient manner and covers all the people, including equity, then it is a benefit to all the people. The intention behind the inserting 29 is restrict the persons from submitting a resolution who could not adverse effect on the entire corporate. Once I have chosen the bad person or not up to the mark person or any bad remarks are there, the total entire CARP process is a wasteful exercise. So to avoid that one, I have to choose the best person. A businessman, a business entrepreneur who is going to take over the problematic company, either in liquidation or etc., etc., etc. And the company to be regained with the help of the skills of the particular person. This would also aid adhering the timelines outlined in the IBC, which were otherwise being hampered due to the exploitation of loopholes in the bidding process. Today, in the bidding process, lot of malpractices are happening, whether he may be the erstwhile corporate debtor or etc. etc. To control these bad practices in the bidding process, so expression of interest is nothing but a bidding process. It is a tender process. In this tender process, you have to choose the best person, not only from the total amount who is going, he is going to contribute for that particular company, but also the company should be continued forever. And once the company is continued, our business operations are continued, it benefited a lot to the economy as a whole. It has been recent times that the adjudicating authority in its few decisions permitted promoters to submit their resolution plan after the company has been declared in service. Some of the judgment earlier also we have seen that adjudicating authority taken their discretion to allow or to give a chance to the earlier the promoters also, because they are the correct person. If honest persons are there, definitely they will run the company in a better manner. But throughout the life of the company, ups and downs are there. Once a down is there, then automatically the company will become non-performing asset. And we have to see the history of the company also. Although such decisions are highly prized by many scholars, and they safeguarded the revival of the defaulting entity. However, others are certainly believe that it will subsequently dilute the intent of the purpose of the Section 29, will ultimately defeat the objectives of the court. So that's why we have to take into account all these factors. Now, what are the detailed, we will discuss in detail about the Section 29A. After that, one NCLAT decision also. A person shall not be eligible to submit resolution if such person or other person acting jointly or in concert with such a person. That is point 1. A person shall not be eligible to submit the resolution plan if such person or other person acting jointly or concerned with such a person. Now, one by one, we will discuss. Here, acting jointly or in concert signifies two or more persons acting together as a group. In case of ArcelorMittal, India versus Satish Kumar Gupta, the Supreme Court laid down that the expression acting jointly in the opening sentence of Section 29A cannot be confused with joint venture agreements. It does not mean certain persons got together or acting jointly in the sense of acting together. So here the expression acting jointly or in concert signifies two or more persons acting together as a group. 1 is an undischarged insolvent. What is meant by undischarged insolvent? An undischarged insolvent is a person or a company has not gone through the insolvency resolution proceedings. In layman terms, a person or a company who filed the petition of a bankruptcy at the court of law and still is going through insolvency is known as undischarged insolvent. So, the 29, they have given some conditions. The first condition is undischarged insolvent. What is meant by undischarged insolvent? It means a person or a company who have filed a petition of a bankruptcy at the court of law is still going through the insolvency. It is in the process. Is known as undischarged insolvent. Next, the second point, Section 29A, second point they mention, is a willful defaulter. For that, whatever the willful defaulter definition that is given by the regulator of banks, in accordance with the guidelines of the Reserve Bank of India, issued under Banking Regulation Act 1949, that is Section 10 of 1949. As per the Master Circular issued by the RBI, that is a Banking Regulation Act, they defined the willful defaulter means or borrower means when he does not meet the obligation even though he can do so. He is having plenty of money, but he is not interested to pay or to clear the loan. Then he is called willful defaulter. The second point, not utilize the funds for specific purpose they have been availed for. Suppose a bank has given loan for working capital, for procuring the raw material, but they have not utilized that funds working capital. They have diverted that funds to other areas. That is also comes under willful default. Siphons the funds neither for the purpose. That is siphoning of the funds. That is also to be categorized as willful default. They were able for now have another form of assets. That is also to be treated as willful default. Dispose of the property of assets which were given securing the loan without the knowledge of the lender. Some of the borrowers, they have given collateral security to the bank. Without the knowledge of the bank, they sell that particular assets to the others, even though the loan is in outstanding. That is also called as a willful default. And misrepresentation. Whatever the financials are there, whatever the information he is provided, that is to the bank at the time of taking the loan, or falsification of reports, particularly the balance sheets or other information or projections or whatever relevant to that particular loan, then fraudulent transaction. All these things are to be considered as willful defaulter. So willful defaulter means not simply the does not meet the obligations even when he can do so. Everybody is thinking about that one only. But other conditions are also clearly mentioned in the section 10 of the Banking Regulation Act 1949 and the Reserve Bank of India, the Banking Regulation Act 1949, they have mentioned. Next, point 3, an account of a corporate data. So you have to verify A, you have to verify B. 2 points you have to verify line by line to how many points he has mentioned in the 29A, all are to be verified thoroughly. Then only you have to give the affidavit. Or safe side, if at all you want to take the affidavit from the prospective resolution applicant, no problem. Once you thoroughly verified all these things, there is no need to take the affidavit from the prospective applicant. And third one is an account of a corporate data under management or control of such a person or from whom such a person is a promoter or classified as a non-performing asset in accordance with the RBI Banking Regulation Act 1949, Section 10, and at least a period of 1 year elapsed. That is important. Normally, the non-performance assets are to be declared by the bank in case of term loans, 90 days from the due date. After 90 days, if the installment is not paid or interest are not paid, then that account to be classified as a non-performing asset. But in case of cash credit or working capital, out of order concept is there. In the out of order concept, the submission of stock statement, the credits are not sufficient to meet the debits, or renewal is not happened within 6 months from the due date. All these things, then the account to be classified as an. So immediately, sometimes the company may take some time to liquidate the whatever irregular amounts are there. But here, they have given time of at least a period of 1 year has elapsed from the date of such a classification. So immediately, if at all non-performing asset is there, that is not to be counted. At least 1 year has elapsed from the date of such a classification. Till the commencement of the corporate, up to the date, the corporate in CIRP is the target date to 1 year to be lapsed. Then only you have to classify that account as a NPA, an account of a corporate data. So that is classified as a non-performing asset. An account of the corporate data. This simply means that when an insolvency entity unable to settle overdues, including interest and charges relating to account before submission of a resolution plan for 1 or more years, whose accounts are classified as a non-performing, is ineligible to be the resolution applicant. What is that one? It simply means an insolvent entity is unable to settle once they have not paid, they have not settled that particular overdue amount, including interest and charges, and account before submission of the resolution plan. Those accounts are classified as a non-performing or ineligible to be a resolution applicant. Next, the judgment of ArcelorMittal, particularly this India Satish Kumar Gupta versus Apex Court interpreted this clause and analyzed the definition of control and observed expression of control 29 denotes a positive control only. So control means a positive control. Who controls that company? Who controls that particular company? In this particular case, Justice Nariman further quoted that Section 29A C is a see through the great care must be taken to ensure the persons who are in charge of the corporate data do not come back in the same other form to regain the control of the company without first paying off its debt. That's why they have clearly mentioned like that. So they should not come back unless they pay back the first debts. In the Justice Nariman point also, particularly Justice Nariman point also, he clearly told this section 29A C, point C, see through the provision, great care must be taken to ensure the person who are in charge of the corporate data do not come back in the same other form to regain the control of the company without first paying of the debts. Again, he quoted, thus it is clear, if the person wishes to submit the resolution plan, acting jointly or in concert with other persons, classified non-performing persons other than persons happens to be either manage or control of the and whose debts have been not paid off for a period of at least 1 year before the commencement of CIRP become ineligible to submit the resolution. So in that case also, he clearly mentioned about once he paid that amount, then only he can participate. Otherwise, he is not eligible as a resolution applicant to submit his resolution plan. And he further quoted, provided that a person shall be eligible to submit the resolution plan, if such a person makes a payment all the overdues amount with interest thereon, charges relating to non-performing asset before submission. Okay, that a condition they have mentioned. Once before submission of the resolution plan, if at all they liquidated whatever the irregular amount is there, then they can be considered as a prospective resolution applicant. In the same, he also told, provided further, nothing in the clause shall apply to the resolution applicant. Such application is applicant is a financial entity, and this is exempted to the financial entities. The financial entities are the banks, the insurance companies, the non-banking financial companies, etc., etc. And he is not a related party to the corporate data. So financial entities, it is not applicable, is not a related party to the corporate data. Any person who is convicted for offense of punishable with imprisonment of 2 years or more prescribed under 12th schedule to the IBC. Once any person is convicted for a period of 2 years or more prescribed under 12th schedule of IBC. If you see the particular IBC code, last 12th schedule they have mentioned. In the 12th schedule, they have mentioned nearly 25 acts are mentioned. In that, through that act, if at all any person is convicted 2 years or more, they are also not eligible. The total of 25 laws mentioned in the above mentioned circular, the schedule, consisting of example, money laundering, or FEMA, or pollution control norms, or tax, or anti-corruption, and security market obligations. If at all the 25 is there, if 2 years particularly imprisonment is there, they are not eligible. But what is the 12th schedule of IBC? In the 12th schedule of IBC, particularly see the clause D of the section 29A. What are those acts? One is the foreign trade. If at all he is imprisoned because of a violation of a Foreign Trade Development Regulation Act 1922, or Reserve Bank of India 1934, Section 2 of 1934, even foreign trade also, Section 22 of 1922, or Central Excise Act 1944, or in Central Excise Act 1 of 1944, or any Prevention of Food Adulteration Act 1954, in that section 37 of 1954, or Essentials of Commodities Act 1955, 10 of 1955, or Securities Contract SCRA Act 1956, in that 42 of 1956, or Customs Act 1962, that is 52 of 1962, or Water Prevention and Control Pollution Act 1974, that is 6 of 1974, or Conversion of Foreign Exchange and Prevention of Smuggling Activities 1974, that is 52 of 1974, or the Air Prevention and Control Pollution Act 1981, in that 14 of 1981, or SICA Act 1985, that is 1 of 1986, or Environmental Protection Act 1986, 29 of 1986. You have to verify all these acts. That's why it is a big challenge. So whether any person, any director, or any individual, or any office, the officer, they have any imprisonment for a period of 2 years under these acts, how to verify? Each and every act, if at all that all 25 act the imprisonment of people data is available, then for IP, it is very easy. Based on the PAN, based on the Aadhaar card, and based on that particular DIN number or etc. Today, most of the cases, today, Aadhaar card number or PAN card number or some numbers are linked. Earlier, that the system is not there. So that's why the verification is very, very difficult. Not only this 13, prohibition of a Benami Property Transaction Act 1988, 45 of 1988, or Prevention of Corruption of Act 1988, Section 49 of 1988, or SEBI Act 1992, that too 15 of the 1902, Section 15 of 92, or FEMA Act 1999, that is a Section 42 of 1999, or Competition Act 2002, that is a Section 12 of 2003, or the Prevention of Money Laundering Act 2002, that is a Section 15 of 2002, or LLP, Limited Liabilities Partnership Act 2008, that is Section 6 of 2009, or the Foreign Contribution Regulation Act 2010, that is 42 of the 2010, or the Companies Act, that is Section 18 of 2013, or any previous company law, or the black money, undisclosed foreign income and assets, and imposition of a tax act 2015, 22 of 2015, or insolvency and bankruptcy, that is 31 of 2016. If at all he is imprisoned under these acts, so any person who has been convicted for offense is punishable with an imprisonment of 2 or more period prescribed under 12th schedule of IBC, then he is not eligible. But how to verify this 25 acts, that to the sections? If at all any centralized server is there, then it is possible. Otherwise, next 25, the Central Goods and Service GST 2017, 12 of 2017, and respect to state acts imposing state goods and services tax or any such other acts may be notified by the central government from time to time. Every notification issued in this schedule shall be laid down as soon as maybe after it's issued before House of the Parliament. 25 acts, whether the prospective resolution applicant are involved in these 20 to 25 acts and imprisoned for 2 years, then he is not eligible. But how to verify? It is a big challenge. Big challenge for the resolution professionals. Okay, even particularly Reserve Bank of India willful defaulters is also a big challenge, and all these things are to be verified. So first you have to verify the A clause, A, that is undischarged insolvent, any court pendings are there, any still it is in the process, and he declared the petition of the bankruptcy pending only, not finalized, pending in the process, or willful defaulters you have to verify, and particularly non-performing asset of the bank, or particularly this 25 acts to be verified. Only up to this point, still some more are there. All this is so. Any person who is convicted of offense is punishable with imprisonment of 2 years or more prescribed under 12th schedule of the IBC. Then only you can give the affidavit. Some other people, they are giving affidavits. without verification. But simply they have to mention all these things. And once you go through that 25, earlier also, some of the big corporates and the directors are also imprisoned on account of that acts. Data is not updated in the particular computer servers. And some of the latest data may be available. What about the old data? A law, the total of 25 laws mentioned above mentioned schedule consisting of money laundering or foreign exchange or pollution control norms, tax, anti-corruption, security market regulation. So that's why it is a big challenge. So whenever we are giving affidavit and without verifying all these things, if at all we have given affidavit, you imagine whether that affidavit is properly given or not. Or in this particular clause only, 7 years or more, any law, that is 2 years or more under those 25 laws, and another law type being in force. This disqualification would be applicable to both Indian laws as well as foreign laws. Particularly, any law means it is both Indian laws as well as. So that's why whoever is offering services, particularly I am giving that 29 verification, we will charge it 50,000 or 1 lakh. Whether he is having this database, whether he will get that full information verifying that particular the 25 acts or any other law, or the willful defaulters law, or the non-performing assets, or the particularly the bankruptcy or other in process undischarged bankruptcy. This disqualification not apply to persons in case already been 2 years or more from the release of the employees. Once the 2 years are completed, then only the disqualification not apply to the persons. Otherwise, it is applied. Otherwise, it is applied. Earlier, FERA Act is there, Foreign Exchange Regulation Act. Foreign Exchange Regulation has replaced with the Foreign Exchange Management Act. Okay, that directors, they may become old people like that. But as today, some of the companies, the directors are aged people are also there. Even though some restrictions are there as per the Companies Act and other things, still some special resolution or Government of India permission, all these things are there. Furthermore, the ineligibility is not applicable connected persons. This definition broad spectrum including holding company or subsidiary company or associated company or related party of the proposed acquirer, its promoters, it acquires board as well as a proposer management of the corporate data or its promoter. This eligibility is not applicable to connected persons. What is a connected persons? It is a broad spectrum including its holding companies, its subsidiary companies, its associated companies, or any related party of the proposed acquirer, or its promoters, or all these things are also covered. However, this condition would not be valid on a resolution applicant who is a financial entity. So, whatever the conditions that are mentioned under this section 29A, not applicable to the financial entities like banks or non-banking financial companies or insurance companies like that. What is meant by financial entity? Everywhere we are talking about financial entity. What is a financial entity? Under insolvency and bankruptcy code, a financial service provider is defined particularly defined as a entity engaged in the business of providing financial services in terms of authorization issued or registered granted by the financial regulators. Either it may be the RBI or it may be the IRDAI. So the definition encompasses a wide range of entities, including banks or insurance companies or NBFCs. So the financial entities, these are not eligible, not applicable. Particularly the resolution plans, the disqualification, whatever it is there, it is not applicable to the financial entities. Next, point E under section 29A. He is disqualified to act as a director under Companies Act 18 of 2000. Disqualified to act as a director. Under section 164 subsection 1 of the Companies Act 2013, a director is termed to be unsound mind or insolvent. His or case pending before the court of insolvency or unsound mind, he or she sentenced for 6 months imprisonment for an offense involving a moral turpitude on order passed by the court or a tribunal declaring him disqualified. He did not pay his call on arrears. Take for example, everybody knows about this one. If the company is going for issue of public shares, IPO, or follow-on public offer, IPO or FPO, the companies are issuing on application, first call, second call, final call, like that. If at all that person is not paid the final calls, did not pay his calls on shares, he has been convicted offense dealing with a related party transaction under section 188 of the Companies Act. For that also he is not eligible. He is prohibited from acquiring director index identification number, DIN. So if at all these things are there, he is not eligible, prohibited from acquiring DIN number. So all these things are also mentioned under section point E of the 29A. How to verify? Okay. The disqualified directors list is available with ROC, and whatever here mentioned, it is available to verify in the ROC with some little bit efforts, then it is possible. So the resolution professional use the ROC website, that is then it is easy for them to verify with the help of a DIN number, with the help of director identification number. Next point F is prohibited by the SEBI from trading in securities or accessing the securities market. This is also to some extent it is possible. The SEBI is also maintaining the database. The database can also be accessed by the resolution profession. Under the section 3 or 4 of the provision of a fraudulent and unfair trade practices relating the securities market, regulations 2003, every person is prohibited to buy or sell or deal in securities fraudulent manner, to defraud on the issue of the security or listed or proposed to be listed on a recognized stock exchange, dealing with the securities fraudulently by the unfair trade practices, that is section 3 and 4 of the SEBI Act. This is possible. This is possible with the help of SEBI database. Section 3 and 4, that is possible. So once the resolution plans are received, evaluation matrix is very easy. But the prospective resolution professional and the prospective resolution applicant due diligence is very difficult. That's why in the Bhushan Stills, the Honorable Supreme Court pointed out this one. Even affidavit is also not the criteria. Once you make the efforts to verify A, B, C, D, now F, then only you have to give the affidavit. Not simply give that. Today, some of the people, without verifying all these things, they are giving the affidavits, which is not correct, and due diligence that is to be done by this resolution professional. Whatever the firms that is offering, they will not verify all these things. Once they are having capacity of verifying that 25 acts or other acts or SEBI Act or the willful defaulters server data, all these things are available, then we can take that services, no problem at all. But today, all the services, it is very easy. That's why in some cases, whenever any resolution applicant is asking any suggestion, I am referring Dun and Bradstreet, and another company is also there. These two companies are, whenever the banks are giving loans, particularly the corporates, they will take then they will charge 10,000 like that, 10,000 like that. Next point, G has been promoter or management control of the corporate data, in which preferential transaction, undervalued transaction, extraordinary transaction, fraudulent transactions are taken place, in respect of which has been made adjudicating authority under this code. So whatever the puff transactions are there, they are not eligible. Even some of the companies, even MSME companies also, even puff report is bad, fraudulent transactions are more, even though they are eligible under MSME, but based on the type of transactions, they are not eligible. So, has been the promoter or in the management or control of a corporate data, in which preferential transactions are there, undervalued transactions are there, extraordinary transactions are there, fraudulent transaction taken place. This is with the help of the none other than transaction audit, and in usage we will defined as the forensic audit. There is no terminology of forensic audit in IBC, but only transaction audit. But usage sake, we are telling that forensic audit like that. Next, in the G itself, provided that a clause shall not apply if the preferential transaction or undervalued transaction or extraordinary transaction or fraudulent transaction takes place prior to the acquisition of the corporate data or by the resolution applicant pursuant to the resolution plan approved under this code or pursuant to the scheme of the plan approved by the financial sector regulator or court, and such resolution has not otherwise contributed the preferential or undervalue, etc. This is also to be verified. This ineligibility takes effect to the promoter or management or control of the corporate data involves a preferential or this one or that. So ineligibility takes effect when promoter of a corporate involved in this particular transaction. This subclause takes positive control over the corporate data. Earlier, I have also told about this one. And therefore, it is clear management or control works on necessary sources. In a simple word, rule is used by the court in interpreting the legislation by interpreting ambiguous word, understanding with which it is associated in this context. So this is also to be verified. Next point is H. He has executed a guarantee in favor of the creditor. How to verify this one? Tell me, sir. Okay. Borrower means the credit information reports are available. But a guarantor in most of the credit information, except the corporate data, that is commercial civil, the guarantors' names are also available. Particularly, the directors' names are available. But here, the individuals, if at all they have given guarantee, and if guarantee is also invoked, how to get that information? How to verify that information about that prospective resolution applicant? In respect of corporate data against whom application for insolvency made by the creditor has been admitted under this code, such a guarantee has been invoked by the creditor and remains unpaid in full or part. Then he is not eligible. So guarantees are also to be verified. How many guarantees? How many guarantees he has given? So if at all we asked the declaration, particularly from the borrower, he will give declaration or affidavit. If you ask, they will provide. But from our side, we have to verify, not the declaration or affidavit basis. This is not affidavit basis. But for all these things, some support function is required from IBC. Then only it is easy. Otherwise, it is a difficult task, challenging task, particularly the verification process, where the data is scattered in a different servers. And a centralized database is not available. And to verify the credentials or antecedents of the prospective resolution applicants, it will take a lot of time. Even though supporting services offered by some agencies, accuracy is not 100%. He has executed in favor of the creditor. This ineligibility occurs when person takes a guarantee of the corporate debtor who is insolvent. This clause is discussed in RBL Bank Limited, MBL and Frost, and held that in case where the creditor has not invoked the guarantee or not a demand or made a demand, the guarantee should not be prohibited. This ineligibility occurs when a person takes a guarantee of the corporate debtor who is insolvent. This clause is discussed in that particular case that a creditor is, this means no default in payment of the dues has been made or therefore cannot be covered under this clause H. This also to be keep it in mind. He has executed guarantee in favor of the creditor. Therefore, subclause understood the extent of objectives of the code or ordinance in general, not regular meaning, or in the context of enforcing the guarantee or the legal binding of the. So this guarantee is also one of the biggest challenge. Directly borrower means it is very easy with the credit the information companies, but this is a little bit difficult. Next, I. Another point, 29A, I. Subject to disability of the corresponding clause A to H under any law in jurisdiction India, and in common parlance, any ineligibility arising the above mentioned clauses will be affect under the law India or outside. So here we are worried about the Indian laws where the data is available, how to verify the data. But in the I also they mentioned not only in India but outside the borders of the India, that is also to be verified. How it is possible? How it is possible? That's why this is a big challenge to the resolution professions. Once simply giving, that's why in that Bhushan stills, he has keep quiet, not giving any declaration that he has verified the this one. So thereby it is a very, 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 very difficult. That's why he keep quiet and he is not submitted the declaration to avoid that one. To avoid, okay. One side it is a issue, particularly the issue means lapses are there, but he wish to safeguard his skin. If at all he is given that statement later on, if at all anything happens, then it will be a problem for him. Next, has a connected person not eligible and a to him. As mentioned above, connected persons has a very broad ambit including holding company, or subsidiary company, or associated company, or any related proposer acquire, all these things are there. But this is also to be verified. Connected person not eligible. And however, this condition would not be valid for the resolution applicant. Who is a financial entity? Financial entities, this clause is not applicable for almost all points in the section 29A. This explanation has been done apex court in the judgment of ArcelorMittal India and Satish Kumar also. And now one more judgment, that is eligibility or ineligibility of a successful resolution applicant under section 29A must be based on date of submission of a resolution plan, date of resolution, submission of the resolution, not before. So the eligibility or ineligibility of the successful resolution applicant under section 29 must be based on date of submission of the resolution plan. This is one judicial pronouncement. I will go through that particular judicial pronouncement. That is a date of submission, not on date of CAR. Date of not a date of CARP, date of submission of the resolution plan. This is a NCLT case, NCLAT case. Eligibility or ineligibility of the successful resolution applicant under section 29A must be based on date of submission of the resolution plan, that is NCLAT noted. This is also the recent judicial pronouncement. So the successful resolution 29A to be verified on the date of submission of the resolution plan, not on the CARP date. CARP commencement date. The tribunal conducted that when section 240A is applied, normally 240A applied. If at all he is a MSME, he is eligible to submit the resolution plan. Ineligibility in the resolution applicant whose management and control on account of the CV was declared non-performing cannot be recalled. Because here 240A and 29A, some conflicts are there. Which is the first? Actually, 240A is introduced after 29A implemented. Not before. Not before. So that's why in this case, what is happened? The Delhi bench of NCLAT held that the eligibility or ineligibility of the SRA under section 29A of IBC has to be seen on the date of submission of a resolution plan, not before that. Not before that. For that, on application filed by financial creditor of the corporate data, Dilwara Leasing Investment Limited, corporate CIRP, against CD commenced the order dated 22/2/2022, passed by the adjudicating authority. Against the corporate data commenced the order so date. What is that one? Here, the application filed by the financial creditor and the corporate data is the Dilwara, on application filed by the financial creditor of the corporate data, that is Dilwara, financial creditor is Dilwara Leasing and Investment Limited. In the sixth meeting of COC, that is in response to the Form G, that is expression of interest, the RP received resolution plans of 6 prospective resolution applicants, which include Vishwanath Trader and Investment Limited. He is the CD. On result of the voting resolution plan, Vishwanath Trader and Investment was approved with 100% votes. That is corporate data. Rajkumar Sahani, the suspended director of the shareholder of the CD, filed an IA number so-and-so on so-and-so date, objecting that the resolution plan submitted by the Vishwanath traders. The CD person only, the one of the director only, he raised that objection. The Rajkumar Sahani, suspended director and shareholder of the CD, and an IA number so-and-so. The applicant contended that Vishwanath Trader is not eligible to submit the resolution under 29A. Hence, the application praying approval of the resolution plan to be rejected. The corporate data, one of the directors of the corporate data, he filed an application praying that the resolution plan to be rejected. Okay. The adjudicating authority allowed the appeal filed by Rajkumar Sahani, held that Vishwanath Trader is ineligible under section 29C of the insolvency. Allowed the appeal. The aggrieved person, particularly the resolution profession, the committee of creditors of the corporate data, as well as the successful resolution applicant, that is CD, have filed an appeal challenging the order dated of the NCLT, that is 24 January 2024. The appellant submitted the registration of MSME after initiation of CIRP. The MSME registrations are submitted after CIRP initiation. Against the CD is unimportant, and the benefit of 240A is also available to corporate data who registered and as an MSME during CIRP. So, the benefit of 240A, that is, he is an MSME. Under 240A, he is eligible to submit the resolution plan and registered during CIRP. But one thing, before commencement of the CIRP, he is not registered with Udyam, the MSME portal. After that, he registered. So the corporate debtor, one of the directors of the corporate debtor contesting, no, he is not eligible because he is colluded with other people. That's why he himself raised that objection. It was submitted that Rajakumar Sahani, the suspended director, was throughout the present in all meetings because he is a suspended director. He is eligible to sit in the COC without voting rights and never raised any objection regarding the corporate debtor as MSME, and further no objection regarding eligibility of Vishwanath traders was raised by Rajkumar Sahan. During the meeting, he never raised that issue. But after finalization of the resolution plan and submitted to the particular, the adjudicating authority, he filed the IA. It was submitted that Section 240A has been inserted in IBC by legislature, and the benefit which ensures the corporate debtor under 240A cannot be denied. It is a special benefit that is extended by the government of India on the recommendations of the Ministry of MSME, that a small MSME, if at all that CARP is initiated, the lot of suffocation, the problems, all are arise. That's why not only that one, they are facing a lot of problem on day-to-day basis to procure the raw material, to sell the products, and some of the amounts they are not getting in time. For that, banks bills discount is there, trades is also there. Even though the factoring and all these things, still they are suffering a lot to get the profit with, and they are facing the competition, cutthroat competition with the large companies, etc., etc. That's why Government of India extended in IBC to protect the MSMEs. 240A was introduced. Per contra, the respondents submitted the present case where SRA, with a design to take the control of CD, has got the CD registered MSME because he is eligible. But here, what is a mistake is during CARP only he registered as an MSME. If you see the turnover or plant and machinery, all are satisfied. It was further submitted that Birendra Kumar Pasari, a person adjudicating and acting jointly in consultation with SRA, which clearly attracts ineligibility of the section 29AC. Virendra Kumar is also a person who is a manager and control of the corporate data, because he is also one of the director. But he raised that objection and he filed that IA. It was further submitted. Commercial wisdom of a COC is not unlimited, which cannot be exercised arbitrarily in derogation of the code and the regulation framed thereafter. The adjudicating authority rightly rejected and resolution plan of the successful resolution applicant at NCLT level. NCLT level. Next, this was analyzed by the tribunal, NCLAT. Section 240A and 29A of IBC observed that Section 240 was inserted subsequent to the insertion of 29A in the IBC. So, the 29A is not after 240A, but 240A was a section introduced, inserted after 29A. The clear intendment of section 240A was to take out the applicability of 29A clause C and H for MSME. The report of Insolvency Law Committee March 2018 recommended that the central government to exempt MSMEs certain provisions including 29A. That's why whatever the resolution plan submitted by the corporate data, that is valid. The tribunal further observed, law declared by Honorable Supreme Court, particularly the same case in Supreme Court also, Haribabu Tota clearly support the submission of applicant that no eligibility shall attach to SRA by virtue of the no ineligibility that is section 29 ineligibility not they shall attach it to the successful resolution applicant by virtue of section 248. This is already one case, a decided case in Honorable Supreme Court of India on this same issue. The tribunal analyzed that 240A and 29A of the IBC observed that section 240 was inserted subsequent to the insertion of 29A and in the IBC. That's why it is valid. The SRA is eligible to submit the resolution plan, and whatever the plan not approved or rejected by the NCLT is not valid. The clear intention of the 240 was to take out the applicability of the 29A clause MSME. This is also recommendations. The bench comprising of Justice Ashok Bhushan and Varun Mitra observed that legislative enactment of inserted give relief to the MSME for the purpose of the objective as noted by the Insolvency Law Committee. And therefore, the MSA being against the intendment for the purpose of the enactment. That's why the corporate debtor is eligible. The tribunal concluded that when 240A is applied, ineligibility in the resolution applicant who's under management control on the account of CD was declared non-performing cannot be reckoned. It cannot be reckoned. So it was viewed that SRA of Vishwanath Traders Investment Limited did not suffer any ineligibility from submitting the resolution plan on so-and-so date, which date the plan was submitted. The 240A also we have to recapitulate that one. 240A of the Insolvency and Bankruptcy provides exception to the disqualification under section 29A of the MSME. Undergoing CAR, specifically it states C and H of section 29A do not apply the resolution applicant in CARP of MSME. What are the C and H? The C and H, earlier we have discussed in detail about the various C and H. This is C, account of the corporate debtor. Even though he is a non-performing asset, then next H, guarantor. Executed as a guarantor in favor of the creditor. So these two are exempted for MSMEs and they are also eligible to submit the resolution plans under 240A. So the 240A, C and H of section 29A do not apply to the resolution applicant in CARP of MSME. This means that a promoter or the person who would typically disqualified under the clause can still submit a resolution plan if the company is MSME. That is a 240A, everybody knows. So we have widely discussed about 29A, some judicial pronouncements, and the details of section 29A, and what are the objections that are raised by the manufacturing associations or some adjudicating authority favors the to finalize the resolution plan that are submitted by the erstwhile corporate data, and what are the different of opinion, and how the 29A is evolved. Initially, there is no 29A, and some of the people they are misappropriated on account of that earlier corporate data they are submitting the resolution, and they are purchasing their company with high discount rates, etc. To avoid all these things and to improve the quality of the CARP process or the liquidation process, they have introduced this 29A, but still some people are having its their opinion, and some gaps are also there. Beyond all these things, beyond all these things, for resolution applicants, verification is a very, very, very difficult, and it is a big challenge for them. 25 acts, other than 25 acts, and other Indian acts, or the foreign acts, or the willful defaulters, or the guarantees, all these things, verification is very, very, very difficult. For this, the IBBA has to give some support services. How to overcome this problem, how to verify. If at all centralized data is not available and the distributed data is available, and some of the old records are not computerized, and some records are latest is available, with all these things, how he will give the affidavit, and if affidavit is not given, like in Bhushan Stills, why they have given that judgment, and they also clearly told detailed thorough verification to be done by the resolution professional. It is very easy to say, but in practice it is very difficult to get all the information. And even though different sources, if at all X source is there, Y source is there, Z source, if at all they clearly told, then it is easy. If they mentioned 25 acts or other Indian acts, and Indian Act and Foreign Act, where the database is available about the particular the prospective resolution applicant, whether it is a qualified or a disqualified, how to verify is a difficult challenge. So in overall, it is a big challenge for the resolution professions. Even though 29A, one section is there, that section is heart of the particular the IBC. If at all you are giving that particular company in the safest hands, hand over to the safest hands, then it helps a lot to the economy. Otherwise, the same problem will be repeated, and thereby it hampers the economic development of the country. So, the conclusion is entrepreneurship thrives on innovation and risk taking. Today, starting the business, continue the business with the cutthroat competition, and a lot of demand and supply gaps are there. It is very, very, very difficult. Sometimes the failures are there. Even all economies also always they are not in a rosy picture. Sometimes the business cycles ups and downs are there. In that particular scenario, widely viewed that the critical components of the success of the economy. Once the success of economy depends upon the entrepreneurship. If at all you are giving a lot of pressures on the entrepreneurs, economy will not go. Some relaxation, some tight and loose systems are available. In a high power distance countries like India, fostering culture risk taking is a crucial driving the innovation and entrepreneurs. One side, make in India concept. Second side, self-sufficiency or Vikasit Bharat, all the government schemes. But once these hurdles are there, how to improve the economy. Then it is a problem. And however, excessive creditor rights can destroy the incentives of the companies undertake value enhancing the risky projects. Today, business is not a cakewalk. Lot of hurdles are there. Once you have crossed that hurdles, then only the profit will come. Otherwise, day one, it is not. That's why we are talking about a break-even point, above break-even point. When the company will reach the break-even point, in the meantime, new companies are entered into the market. One side, technology innovations and all these things. One side, the demands of the customers, low price and quality products. All these things are there. Enhancing the risky projects and promoters might choose the unprofitable diversifying investment to reduce the profitability distress. This contradicts the court's key objective promoting enterprise. One side you are talking about promoting entrepreneurship in the code. Second side, the barriers are there, the challenges are there. So where that is to be balanced properly. The code is also to be balanced properly. The legislature has a time and again recognized the importance of the promoters' involvement. Suppose we are talking about on the IP, on the CEO of the company. I don't know the production department. I don't know about the functioning of the finance department. I don't know about the marketing department, how it is functioning. I don't know how to function the HR department. But you are the CEO of the company. You have to manage the company effectively and efficiently as a going concern with the least cost and the maximization of revenue through resolution plans. All these things. It is a big challenge for the prospective resolution and the prospective resolution professions. This is reflected in the section 12, which allows the withdrawal of the CRP proceedings, and section 240A restrict the applicability clauses and H29 micro enterprises. So why that 29 withdrawal? Because the company should be under the control of the same management. He knows the A to Z. He knows the creditors. He knows the debtors. He knows how to manufacture. He knows how to maximize the profit. He knows how to control the manpower, etc., etc. If at all one IP is handling that without that much knowledge, that much experience, how he will handle that company as a going concern. However, these steps are, despite being laudable, fall short due to wide ranging of her. Now 29. Right from the admission of the petition till the corporate death of the CD. Corporate death of the CD is nothing but a liquidation. Once you split the company bits and pieces and sell, company will disappear from the register of companies website also. Once the company is not there, they will remove the company from the ROC this one. The legislature should review the application of 29A, particularly section 230 of the Companies Act and a liquidation of the code align with the objects proposed by the code, allowing erstwhile management to take the part of this process once CIRP is failed. Some leverage is required, some concentration, genuine cases, honest promoters. That is also required. What is section 230 of the Companies Act says? Section 230 of the Companies Act provides framework of company to propose compromise or arrangement with their creditors or members, particularly when facing the financial difficulties or needing the restructure. Once you are talking about a favor in the Companies Act, once you are talking about 29A is there, this is a wide difference between the IBC and the Companies Act. It allows the meeting of the creditors or the members convened the tribunal. This is also handled by the NCLT only. 230 is also handled by the company NCLT only. As per the NCLT, with the company creditor or member applying for the arrangement. The key aspects of 230 is purpose to facilitate the debt restructuring settlement of the disputes. or changes in the capital structure under approval of the supervision of NCLT. Application. The company, a creditor, or the member can apply to the tribunal for this compromise or arrangement. That facility is there in one act, and the facility is not there. Both are handled by the company law tribunals only. Tribunal role. The tribunal can order meetings of the creditor or members consider the proposed arrangement to ensure fairness and transparency in the process. Disclosure requirements. The company required to disclose the relevant information about the financial health, audits, legal issues to the tribunal and its stakeholders. One side you are listening and the corporate data is a problem. Second side, you are telling under 29A, you are not eligible. And these two are conflicting with each other. Notice and of voting. All involved parties must receive the notice. This is the compromise and arrangement process. And valuation. This here also valuation is there. Ratio value may be required to provide the valuation and the company assets and shares. Both are more or less one and the same. But one act clearly tell about positiveness towards the existing corporate data. Another act is our code is telling the negative side of the particular corporate data should not be participated in the resolution plans. Approval. The compromise or arrangement requires approval of the required majority of the shareholders and creditors. Scope. The arrangement can be debt structure, share capital adjustment, and other changes of the financial structure. That is possible in 230, that too in Companies Act 2013 only. And one side you are inviting the existing promoter, second side you are not allowing the existing promoters to participate in the resolution plans. Transparency and protection. The process emphasizes the transparency and protects the interest of all stakeholders involved, including creditors, members. Here also, all people are there. We are not living in compromise or arrangement. The creditors are there, members are there, or all the stakeholders are there. There also, IBC also, all stakeholders. So the concluding statement is, it is imperative to move away from the stereotypical view of promoters as wrongdoers and embrace the inclusive approach aligned with the code objectives and the purpose. Okay, we should eliminate. Always we are favor for wrongdoers to eliminate that. But honest people, honest corporators, and how the industrial growth will happen, how we are going to Vikasit Bharat by 2047. Is it possible? If at all we are killing the company through liquidation, it may not be possible. But some leverages that side or this side is very much required. Thank you very much for patience listening from 2:30 to 5:30. Thank you very much to all, and I wish you all the best to all the professionals. Thank you, sir. Thank you, madam.
Thank you.
Thank you very much, sir, for such a nice session.
Okay, madam. Thank you, madam.